Sir, on the cell phone, could you identify yourself?
Yeah, Jonathan Friesman.
Jonathan Friesman. Okay, thank you. We're on the record in docket. Is this Mr. Quillen?
Yes, Your Honor.
Yeah. We're on the record in docket 21-02449. People of the state of Michigan versus Martin Quillen. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigl, on behalf of Martin Quillen, who's seated to my right, Your Honor.
And sir, you are Martin Quillen?
Yes, sir.
Okay. This is the time set for a preliminary examination. Ms. Smith, how are we proceeding?
Thank you, Your Honor. Today, I believe the defendant is going to waive his 21-day timeline for preliminary examination. The people would also waive their right to have that exam within 21 days. The defense is requesting a brief adjournment. Mr. Quillen has decided that he would like to try and retain private counsel and just needs a bit more time to be able to gather the retainer and then for us to be able to get discovery to that attorney. The people have no objection to the defendant's request.
And is that your understanding, Mr. Feigl?
It is, Your
Your
Honor.
client is seeking to get private counsel, and so your client's going to waive his right to a preliminary examination within 21 days today.
That's correct, Your Honor. I understand he's met with several different attorneys.
All right.
Should have something done shortly, Your Honor.
May I inquire your client of his waiver of the 21-day rule?
You may, Your Honor.
Mr. Quillen, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. You understand that?
Sir.
And so what that means is a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Mr. Feigelson is your public defender right now. He would be here to contest any charges and cross-examine any witnesses brought in that hearing. It's my understanding today that you wish to retain your own counsel. And if we do that, we're going to be outside that 21-day period. So it's my understanding that you wish to waive your right to a prelim within 21 days. You're not waiving your right to a prelim, only to have it within that 21-day period. Is that your wish today, to waive your right to a prelim within that 21-day period?
Yes, sir, Your Honor.
Okay, and the prosecutor's also waiving their right to a prelim within 21 days?
We are, Your Honor.
All right. So I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. Mr. Quillen is seeking independent counsel. How long do you think we need for this? In order for discovery, new counsel and discovery?
So
I'd say
that's,
probably about, if not 30 days, something about that time. I know we have an exam set on the 11th in front of Judge Allen. We were thinking maybe the Thursday before that in this courtroom with the
So so April 11th is in front of, I'm sorry.
Judge Allen.
Mr. Quillen has a companion case in 55th District Court as well. That exam was supposed to be this week. We've pushed that out to April 11th.
That's a Tuesday?
It is a Tuesday. So we were originally thinking the following Thursday or Friday, but I start a jury trial with Judge Aquilina that week. And
Okay.
then I start a homicide trial the week after that.
You want to do the week before?
Well, as Mr. Feigelson was just
Yeah.
speaking, I'm thinking that's really only a 1-week adjournment.
Let's try, yeah, that is, that's.
So I don't know that that's very
Maybe the,
fruitful.
maybe the 20th or 27th
I'm gonna still be in my homicide trial.
on the 20th.
So I start a child abuse on the 13th that will run through the 20th, and then I pick a homicide jury on the 21st that will run through the 4th. So the first week I would be available is the second week of May.
That's the 11th.
Correct, Your Honor.
So
What if we did that on April 14th, the same week of another?
I think she's still in trial.
Yeah.
I would be. The only day that I wouldn't be in
I'm
trial is
sorry.
Wednesdays. And I know that the court has other obligations.
Yeah,
on
we have
Wednesdays.
landlord tenant on Wednesdays. So I think that the closest date is the 11th, May 11th, which would put it at about 6 weeks.
Yeah.
How does that date look?
Mhm. Yeah, I agree.
Yeah. Just. Whatever.
Yeah.
So PCC, they don't have anything scheduled.
All right,
except-
let's do it that day.
You don't have anything scheduled except the forensic review.
What time do you want? 8:30? All right, we'll do May 11th at 8:30. That will be after the 55th case, so you should have some understanding of where this case is going.
Correct, Your Honor.
Understood, Your Honor.
All
Thank
right,
you.
anything else for the record, docket 21022449?
Your Honor, I do want to just make one point on the record if I could.
Sure.
It's not with respect necessarily to the defendant. At this point, I would need more information, but I did meet with the minor child victim and her family yesterday. They have told me that they are continually being harassed and contacted by the defendant's wife, Hope. And so I don't have any reason to believe that the defendant is directing that contact or anything. But if the defendant was willing to speak to his wife about not doing that, I would certainly appreciate it, and it would save me having to investigate her for potential witness intimidation or witness interference.
Mr. Feigelson?
Yeah, I'll talk to his wife and so will Mr. Cole. I do know that they're related.
It's her grandma.
It's her grandmother's house. I know there's.
Her grandmother takes care of our children.
All right, just as long as there's an understanding that there's no direct or indirect contact. Yeah, and so if there's any conversation, let's keep the case out of it for
Right.
now. With that understanding, anything else on the record, docket 21022449, Ms. Smith?
No, Your Honor, thank you so much.
Mr. Feigelson?
No, thank you, Your Honor.
So, so make sure when you get a new lawyer that they contact the prosecutor's office right away. Until that appearance is filed, Mr. Feigelson's still your lawyer, okay? All right, that's all for the record, docket 210249.
Okay, sounds good.
You signing that now?
Yeah. I'm doing
Yeah, I just think now
Which
that
case is that?
it seems like April's so far away, but in reality. it's so it seems just better to put it out.
Somebody can stand in for Mr. Abbott or?
He had some matters down the hall, you know.
If I see him, I'll
Okay.
put him down here.
I think this is.
Oh, it's done. I can stand in. I'll stand in for him.
Yeah.
I think it's just
Yeah, I'll stand in. That's good enough for me. Take care, Mr. Cole. Yeah. I can stand in the best of my.
all right, Mr. Friesman, I'll need for you to unmute yourself. It'll be *6. There you go. You're good. And we'll go ahead and once the paperwork's done, we'll go ahead and call your case. All right, sir? Thank you, Mr. Stevens. All right, so we're on the record in docket 23-00457. That's people of the state of Michigan versus Jonathan Friesman. Will the parties please introduce themselves for the record?
Andrew Stevens on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, standing in for Mr. Abbott briefly here this morning on behalf of the defendant.
All right, sir, you are Jonathan Friesman.
Yes, Your Honor.
Okay, and you can hear me all right, Mr. Friesman?
Yes, Your Honor.
All right, this is the time set for preliminary examination today. Mr. Stevens, how are we proceeding?
Thank you, Your Honor. I have executed a nollie pros for this case upon review and sort of speaking with the victims or the witnesses in this case. The people are unable to sustain their burden of proof on the charged offenses. And so at this point, consistent with the nollie pros, people are moving to dismiss.
All right. Based on the prosecutor unable to proceed today, based on uh, so based on conversation with victims. All right, so Mr. Friesman, I'm signing the order of dismissal. So I've signed the order of dismissal based on the inability for the prosecutor to proceed today. And your case is dismissed without prejudice, which means they could reissue if they choose to. For our purposes today, the case is dismissed. All right, Mr. Friesman?
Thank you, Your Honor.
Anything for the record, Mr. Feigelson, on docket 23-00457?
No, thank you, Your Honor.
Anything else, Mr. Stevens?
No, Your Honor, thank you.
All right, Mr. Friesman, you're all set. Your case is dismissed without prejudice.
And Judge, can we get a
Thank
copy
you.
then? Like, you get a chance?
Once Nathaniel gets in, once he
Perfect.
comes back up, yep.
Thank you.
So you're all set. You can leave the Zoom courtroom. Thank you for your appearance today.
Thank you.
Mr. Abbott,
Was 3 minutes too late.
that's all right. We rather than track you down, Mr. Feigelson could stand in for you for dismissal. I'm sure one less case on your docket is fine.
No argument from me.
All right, so we're on the record in docket two files, docket 22022591 and 22033433. That's people of the state of Michigan versus Mark Mitchell. Will the parties please introduce themselves for the record?
Andrew Stevens on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson standing in for Aaron Robinson on behalf of Mr. Mitchell, who's present via Polycom from the Union County Jail.
And sir, you are Mark Anthony Mitchell?
Yes, I am, Your Honor.
All right, thank you. This is the time set for preliminary examination on both of these files. Mr. Stevens, how are we proceeding?
Thank you, Your Honor. Drawing your recollection back a couple days, you'll remember that Mr. Mitchell had a pair of misdemeanors set for your Honor's pretrial docket. And Ms. Robinson and I placed on the record sort of our intention. We were sort of hopeful that we could have all of this wrapped up before today. Nevertheless, to remind the court, Mr. Mitchell has approximately 11 cases spread across the county in every district court within Ingham County. Ms. Robinson and I are working to get Mr. Mitchell assessed for eligibility and entry into the 54B District Court Drug Court Specialty Court. And so we just need some additional time for that. What I have already proposed to Ms. Robinson, and certainly Mr. Feigelson probably isn't necessarily aware of this, is for Mr. Mitchell, the idea would be for Mr. Mitchell to be pleading guilty to one of the felonies and one of the misdemeanors that are pending in 54B. So we don't have to do any extra hurdles as far as transferring cases.
Right.
And if he's eligible and he accepts that, then it would be dismissing sort of everything else across the county. So that is the status of all of Mr. Mitchell's cases. With that sort of long preface or preamble, it is my understanding that Mr. Mitchell will be waiving his timeline on these two felonies today, so that we can facilitate all of that.
All right, and that's your understanding, Mr. Feigelson?
It is, Your Honor.
And the people will also be waiving their 21-day rule timeline?
Yes, Your Honor.
Mr. Feigelson, may I inquire of your client, Mr. Mitchell, of your waiver of the 21-day rule?
You may, Your Honor.
Mr. Mitchell, you heard the prosecutor talk about consolidating some cases. You have a right to a preliminary examination within 21 days of your date of arraignment on both of these files, 22022591 and 22033433. A preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You, of course, are represented by Ms. Erin Robinson. Mr. Feigelson stepping in for Ms. Robinson today, and she would be present to cross-examine any witnesses, and contest any charges brought against you. Do you understand that, sir?
Yes, sir.
And so it's
Yes,
my
sir.
understanding you wish to waive your right to a prelim within 21 days in order for a global resolution and also for assessment concerning a 54B court. Is that my understanding, sir?
Yes, Your Honor.
Okay, so it is your wish today to waive your right to a preliminary examination within 21 days of your date of arraignment?
That would be correct, Your Honor.
Sorry, I can't hear you.
That would be
Oh, that's
Your
correct?
Honor.
Okay. All right. You're not waiving your right to a prelim just within that 21-day period. So that's my understanding, Mr. Mitchell?
That is correct, Your Honor. May I speak with my attorney for 1 second, Your Honor?
You sure can. Mr. Feigelson's present. If you want to step in, I can put you in a breakout room just to explain it to him. It's probably kind of new. Yeah, Mr. Feigelson's here and he can explain to you. All we're doing today is making sure that there's a global resolution on all your files, but I'll make sure that your attorney meets with you in a breakout room to explain that, okay? All right. Once Mr. Feigelson joins us, he's stepping in for Ms. Robinson. I'll place you both in a breakout room, okay?
Okay, Your Honor.
All right.
Hey, Mr. Mitchell, how you doing?
How you doing?
All right, Mr. Feigelson, we'll go back on the record once we get a prosecutor in the, we'll finish the 21-day,
Hey, Judge,
21-day rule.
can I get somebody to open the stairwell behind your courtroom? Because I went there to talk and they locked me out.
Sure. Hold on.
Yeah.
Be with you in a second.
Yeah.
All right, we're back on the record in docket 22-02591 and 22-03433. Mr. Mitchell, you had the opportunity to speak with Mr. Feigelson concerning both of these files?
Yes, very good conversation.
All right, and so it's your wish, and you have an understanding that we're going to adjourn today's matter on both files, 22-02591 and 22-03433. In order to adjourn it, we need a waiver of the 21-day rule. We're adjourning it, so there's a global resolution and to get an assessment for you. Is it your wish today to waive your right to a prelim within the 21-day time period?
That's correct.
All right, and Mr. Stevens, you're also waiving people's right to waive
Yes,
to
Your
a
Honor.
prelim within 21 days?
Yes, Your Honor, thank you.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And do we have some sense of a time frame?
So I was told approximately 30 days, and that's largely because, as I understand it, the probation department over at 54B is in a interesting, and yes, I think Mr. Frankel
They
said
can
it,
join the club.
an interesting state of turmoil. So that was sort of the timeline I'm given. I anticipate it will be faster than that,
So
but
so are we looking at around April 20th?
I think that's fine.
So let's see what's available.
Let's do April 20th.
All right.
As I'm sure if there's a resolution faster, we'll get with the court ahead of time. I'm sure Ms. Robinson.
All right. We'll set this for April 20th at 8:30. So, Mr. Mitchell, your prelim is reset for April 20th at 8:30. That should get everybody time to do what they need to do. If you have any questions, please keep in contact with your attorney, who's Aaron Robinson in the case. Anything else on either one of these files, 22-03433 or 22-02591, Mr. Stevens?
Nothing from the people.
Mr.
Thank you.
Feigelson?
Nothing for the defense.
All right, you're all set. You're all set, Mr. Mitchell. Thank you for your appearance today. Mr. Austin, do you have the chance to talk to your client?
Yes, I have, Your Honor.
All right. Well, that's Miss Housefield, right?
Correct.
All right.
We could do Fox.
Right.
Take care, Your Honor.
Thank you, Mr. Feigelson.
Yeah.
Just try to pull it.
And your client's ready on it, okay, come on, Mr. Fox. So we're on the record in docket 23-00589. That's People of the State of Michigan versus Gregory Fox. Will the parties please introduce themselves for the record?
Jeff Bratto, on behalf of the people, Your Honor.
Luke Goodrich from the Public Defender's Office here to represent Mr. Fox, who's standing to my right.
Sir, you are Gregory Fox?
Yes, sir.
All right, this is the time set for a preliminary examination in the matter. Mr. Brodowitz, how are we proceeding?
Oh, thank you, Your Honor. After conversations with the defense, the people in this matter would move to add a count 2, which would be attempted resisting, obstructing, or assaulting a police officer, which is MCL 750.81D1A, and that is a 1-year misdemeanor, $1,000 fine. And then I believe that it is the defendant's, the defendant will plead guilty to the added count 2. And then upon successful plea and sentence, the people would move to dismiss count 1.
So that's an added count 2, right?
Yes, Your Honor.
And Mr. Goodrich, is that your understanding of the plea agreement or plea negotiations?
Yes, it is, Your Honor.
All right,
Would the court like me to approach with the advice of rights form?
please. Thank you, Mr. Goodrich. All right, I'll restate that for the record so we make sure we're all on the same page. This is concerning we're going to add a count 2 of attempted resisting and obstructing pursuant to 750.81D, parents 1, parents A. That's a 1-year and or $1,000 misdemeanor. With a plea to that count 2. Count 1 is to be dismissed. Is that your understanding, Mr. Goodrich?
Yes, Your Honor.
Okay, may I inquire your client of his advice of rights concerning the misdemeanor plea?
Yes, Your Honor.
Sir, you've written an advice of rights indicating that you understand your rights in this matter in this misdemeanor plea. Is that correct?
Yes, Your Honor.
And you've signed that document?
Yes, Your Honor.
All right. So I'm not gonna go. You understand the maximum penalty in count 2 is a 1-year maximum and or $1,000. You understand that? All right. I'll just go through 3 rights with you since you've indicated. The first right is you understand you have a right to trial by jury in this matter. Your second right is you understand you have a right to trial. You have the right to counsel in this misdemeanor matter. You're of course represented by Mr. Goodrich, and he would cross-examine or contest any charges brought against you. You understand that at trial you have the right to remain silent. You do not have to take the stand if you choose not to. Do you understand that?
Yes, Your Honor.
All right. It's your wish to plead guilty to the offense today and to waive any trial rights you have in this matter. All right. I'm going to bring your attention back. So I'm going to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
I'm going to bring your attention back to September 23rd of 2022 at the offense location of 1215 East Michigan Avenue in the city of Lansing, Ingham County. Were you at 1215 East Michigan Avenue in the city of Lansing, Ingham County on September 23rd, 2022?
Yes, Your Honor.
All right. And at that time, did you attempt to batter, wound, resist, obstruct, oppose an officer who was marked as an officer, Marquise Washington of the Lansing Police Department? So let me ask you this: what did you do that makes you guilty of the attempt R&O in regards to the Lansing Police Department officer?
I resisted by using arms.
Okay, so you resisted him while he was trying to make an arrest on you, and he was in a uniform at the time.
Yes.
All right. Any questions concerning the factual basis, Mr. Brodowitz?
No, Your Honor.
There it goes again. I just named you again. Brodowitz. Anything on the factual basis, Mr. Goodrich?
No, Your Honor, I just want to bring to the court's attention that he was being taken into protective custody due to suicidal
All right.
threats, and that was where.
So that was the nature of the attempt R&O?
Yes.
Okay. I find the factual basis to be understanding, voluntarily, and accurately made. I'm going to refer this to probation. for pre-sentence. So what I'm gonna have you do today is go down to the 5th floor. Mr. Goodrich will tell you this. Go down to the 5th floor and talk to the probation department there. They're gonna ask you questions. They're gonna prepare a report for me. And then you and I will see what options are available in the next few weeks, okay? We're setting sentencing date a little further out ourselves because we have the same problems as 54B. So the sentencing date is,
Excuse me, May 23rd at 1:30.
so the sentencing date will be May 23rd at 1:30. So you'll go today and we'll set it for sentencing on May 23rd. Keep that date. You'll get a notice of it. You're still under all your pre-trial release orders, all right, sir?
Yes, sir.
All
Yes, Your
right.
Honor.
Anything else for the record and docket 23-00589, Mr. Brodowitz?
Not from the people, Your Honor.
Anything, Mr. Goodrich?
No, Your Honor.
All right, we'll see you on that. We'll see you on that May date, Mr. Fox, okay?
Thank you, Your Honor.
Thank you.
Ms. Housefield, how are you?
Good morning, sir. How are you?
I have not had the morning you've had.
I don't know if that's a good or bad thing.
Well, I think
Not
it's-
sure what my morning's been.
Well, you've been busy. I know that.
Oh, fair.
Yeah. We've been busy, but it was more along the lines of making sure that Mr. Feigelson was out of the stairwell.
Oh, I just can't wait for that story.
Well, that we should have a sign on it that door
Oh,
locks.
why would that? That
Well,
would-
that happened to Mr. Stevens too. So I mean, you know,
Also, you know.
yeah. There are a couple stories here.
Some of us might do it on purpose. Just take a break. Yeah. I'm not reading that right now. So I just have that, 'cause I have-
Well, you take some back down, see.
So we have Booton and Gary. Let me know what.
Well, I understand Mr. Gary is in custody, I believe. We can go on the record, Your Honor, and I can.
All right.
We can go from there.
Yeah. And then we do have a arraignment file on Mr. Gary too. So let's just start with the preliminary examination file. Or I'll call that file and then we can address the second file also. So we're on the record in docket 23-00712. That's people of the state of Michigan versus Jerry Gary. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Gary. He's present with me at council table.
And sir, you are Jerry Gary?
Yes.
Okay. This is the time set for preliminary examination on this file. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. It is my understanding from speaking just now with defense counsel that Mr. Gary intends to run the preliminary examination on this file. My apologies to the court and to defense counsel. When I came in, that was not my understanding. One of the two officers on this file has just had to step away for a moment. He will be back, but it may be a few moments until I can call a witness for this case.
All right. I don't have any problem with that. So Ms. Ross, since you're standing, we're going to start the prelim, at least start the prelim. They're both interns, so they're so so it's my understanding that we'll at least call a witness to start the prelim in the matter. Is that your understanding, Mr. Austin?
Yes, Your Honor. It's my understanding Mr. Gary wishes to exercise his right to have his preliminary.
All right. So let me know when the witness is ready. In the meantime, he's got a new file and we can arraign him on the new file right now. So while we have him here, while we're on the record, let's go ahead and start. So the new file is docket 23-00927. That's people of the state of Michigan versus Jerry Gary. council appearances for the record, if you choose.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Morning, Your Honor. Jared Austin appearing on behalf of Mr. Gary for the purpose of arraignment only on this file. He is present with me at council table.
And sir, you are Jerry Gary?
Yes.
This is arraignment on a new file today. And so I'm going to indicate for you the charges that have been alleged against you, and then some of the nature of those charges, what we're doing in regards to those charges. So the nature of those charges are that on April 21st of 2022, it's alleged that at the offense location of 401 South Pennsylvania Avenue in the city of Lansing, Ingham County, yourself, Jerry Jamar Gary, did in count one, deliver less than 50 grams of a mixture containing the controlled substance of cocaine, contrary to the laws of the state of Michigan, that being 333.740, parents 2, parents A, parents 4. That's a felony, 20 years and or $25,000. A consecutive sentence may be imposed for any other felony conviction. There's a second offense notice that goes along with this. To take notice, the defendant was previously convicted of a felony or attempted to commit a felony in that on or about April 13th, 2022, he was convicted of the offense of possession of cocaine less than 25 grams in violation of MCL 333.7432A5 in the 30th Circuit Court for Ingham County. Therefore, defendant is subject to the penalties provided by MCL 769.10. That's 1.5 times the maximum sentence on primary offense or a lesser term. The maximum penalty cannot be less than maximum term for first conviction. So you understand that count one is the 20-year conviction, 20-year and $25,000, along with a habitual offender second notice. Do you understand that that's the charge, sir?
Yes.
The allegation at this time.
Yes.
All right. You understand that you have the right to in this felony case, you have certain rights, and I'll indicate those rights for the record. You have the right to have trial of any kind. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have witnesses appear and testify on your behalf. You have the right to have questions those witnesses. You have the right to have the court order any witnesses in your behalf appear. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. You are represented by Mr. Austin for our purposes, for arraignment purposes. Do you plan to seek additional representation from the public defender's office on this file? I'm assuming since you have it on the other file, you'll have it on this file too. All right, I'm going to indicate yes for the register of action for the ROA. Do we have a prelim date for this?
Excuse me, we do. The PCC will be April 6th at 8:30.
Okay, so the PCC in this case is April 6th at 8:30.
And the prelim to follow on April 14th at 8:30.
And the prelim is April 14th at 8:30.
What did you say this occurred?
That the allegation is that this occurred on April 21st of 2022.
Yeah. Yeah.
All right. Do you have a current address for the court file, sir?
I have 5303 South Cedar.
5303 South Cedar.
That's where my mail goes to, the DHS office.
All right. And is that, all right. And what's the zip code there?
48911.
Do you have a phone number for the court's file?
Yes, I do. 505-8793.
79. What's the zip code there? Is that a 517?
Yes.
You're currently incarcerated. Are you on probation or parole?
No, sir.
I'll enter a not guilty plea for purpose. Oh, so the PCC date is April 6th at 8:30. The preliminary examination date is April 14th at 8:30. I'll enter a not guilty for purposes of arraignment. Mr. Austin, would you like to be heard on bond?
Yes, Your Honor, if I may.
You may.
Thank you, Your Honor. Mr. Gary informs me that he has lived in our community for approximately the last 10 years. He also does have family in the area. My understanding of Mr. Gary's prior criminal history primarily consists of either drug or property-related offenses, is that his criminal history does not, certainly not the majority consist of anything violent or assaultive. Presumption afforded to Mr. Gary is that he did not commit this offense. And he tells me that when he is released on bond, that he shows up to court. Given that, Your Honor, that Mr. Gary is currently incarcerated with a bond he can't afford to post, he would have very little money to post any kind of a bond on this matter. I would ask the court to impose a very reasonable bond that he could reasonably post. Thank you.
Ms. Housefield, any comment on this case?
No, Your Honor, I leave it to the discretion of the court.
All right. If you're able to make bond, I'll set the following bond conditions. There's no use of drugs or alcohol, no out-of-state travel. Cheat sheet. Make sure I can read the codes correctly. No use of alcohol or drugs. No assaultive behavior. That's the one. No out-of-state travel. No firearms. Report to pretrial services within 48 hours of your, if you're able to make bond and be released. The bond on the other file is 10,000, 10%. I don't see anything that would indicate that the bond should be different on this file. I'll set it at 10,000, 10%. Anything else for the record on the new arraign file of 23000927, Ms. Housefield?
Yes, Your Honor, thank you. Looking at the complaints that are filed in each of the files, Your Honor, there are two different middle names in the file that the court has just addressed. It's Jamar, Jimar, and in the file that the court is scheduled for a preliminary examination today, it's Jamal, Jimal. I would ask that the court inquire of the defendant the proper name based on the conflicting complaints so that we can properly file.
All right, so on the file that's set for preliminary examination today, the information reads Jerry Jamal, Jimal, Jerry Jamal Gary. Is that a correct spelling of the name?
No.
Jimal?
No.
How do you spell your middle name, sir?
Jimar.
And that is the correct spelling on the second file, the arraigned file is Jimar. Okay.
I was gonna say, Your Honor, on the first charge for the less than 25, I had posted bond and my bond had got revoked on accusations or something. So they revoked it by the bondsman. And my bond went from 10,000 to 2,500, 10%. I haven't even been to court and they still revoked my bond. They tried to bring me down here and bring me to jail. They refused to house me here. Then they said they was gonna release me at the Mason jail and they never did. So that same Monday that they picked me up, they arraigned me and I didn't go in front of no judge. So by me not going in front of a magistrate, it went from the 10,000 from the first bond to 2,500, 10%. Do you have that on file?
We don't have that on file on the new arraigned charge.
Not the new one, the first one.
On the first one, I just have that the bond is set for 10,000 and 10%. We'll look into it for you on that, but we're starting a prelim on that file today. But I'm not changing bond until I hear a comment from your lawyer or the prosecutor on the case. But at this time, on the arraigned file, I'm going to keep bond at 10,000, 10%, just so I know you're going to be here, because that seems to be an issue if you were remanded on another charge. So I think we have the correct spelling of the name now, Jaimar. Anything else on the arraign file of 23-00927, Ms. Housfield?
No, Your Honor, thank you.
Mr. Austin?
Nothing on the new file,
All
Your
right,
Honor.
so
Thank
that's
you.
all for the new file. And then for the preliminary examination, I'll wait to hear from you, Ms. Housfield.
Thank you, Your Honor. I will go see if I can grab a witness right now.
All right. That's the prelim file.
Show me where it is posted. I don't know if they revoked it under how it's charged. I think it shows surrender to.
All right.
I know. Back and forth to the retail pro.
Oh.
Oh, that was round base.
No, I didn't.
Ms. Powell, how are you?
I'm good, how are you?
Good. All right, so let's go ahead and call that case then. I'm gonna have you stand right here in front of me.
Gotcha.
All right. So we're on the record in docket 23-00712. It's people of the state of Michigan versus Gary Jerry. Ms. Houseville, you ready to call your first witness in that prelim?
I will, Your Honor. Just prior to calling the first witness, I will advise the court and defense counsel on the complaint. The address listed is 420 South Grand Avenue, City of Lansing, Ingham County. In fact, I believe that the proofs will show that as to count one, the location will be 120 West Michigan Avenue, Lansing, Ingham County.
All right.
Thank you, Your Honor.
All right, and you're ready to call your first witness?
Yes, Your Honor, thank you. The people would call to the stand Officer Maxwell McCrory.
All right. I'm gonna have you state your first name and your last name and spell both names for the court recorder.
That's right. Maxwell McCrory, MaxWellMcCrory.
Okay, please raise your right hand. You solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, Your Honor.
All right, have a seat there. Please project for recording purposes, okay, sir?
Yes, sir.
All right, Ms. Housefield, you may proceed.
Thank you. Good morning, sir.
Good morning.
Are you employed?
Yes,
And where are you employed?
Lansing Police Department,
How long have you been with the Lansing Police Department?
8 months.
Were you on duty on March 3rd, 2023?
Yes,
And what did your duties that day include?
patrol, answer calls to service.
How were you dressed on that date relative to your assignment?
Full police uniform.
Were you in a patrol vehicle?
Yes,
And is that a marked or undercover unit?
fully marked.
And on that date, at approximately 21:23 hours, were you dispatched to the area of 420 South Grand?
Yes,
Are you familiar with the Lansing city limits?
yes,
And is that location within the city of Lansing, county of Ingham, state of Michigan?
yes.
Why were you dispatched to that location?
I was dispatched for a trouble subject.
And what is the address of 420 South Grand?
That is the CATA station.
Did you proceed to that location?
Yes,
And when you were dispatched, what information did you have?
there was a male that assaulted a CATA security guard and may have urinated on the bus. And he was actively fighting with a CATA security guard.
When you proceeded to that location, upon your arrival, what did you do first?
I got out of my patrol vehicle and witnessed CATA security guard trying to restrain Gary on the ground. I ran over to assist him, placed my knee on his back, used my body weight to pin him to the ground and trying to restrain him.
Now, when you say you observed the CATA security guard, how did you know that it was the CATA security guard?
I was there earlier the night, same uniform. I recognized the male.
And you said he was detaining or restraining, pardon me, Gary. When you say Gary, who do you mean?
Gary.
And did you have contact with the person that you have identified in your testimony as Jerry Gary?
Yes,
Do you see that person here today?
yes.
Could you please point and indicate something that the subject you know to be Jerry Gary is wearing in court today?
He's sitting right there, Gary, in a jumpsuit.
Your Honor, may the record reflect that the witness has identified the defendant.
Any objection to the witness identifying the defendant for purposes of prelim?
Without objection.
Okay, without objection, the witness has identified the defendant.
Thank you. Now, at the time, sir, you indicated that you placed your knee on his back and attempted to restrain him. At this time, what did the security guard do?
The security guard was on the other side of him, on the right side, still trying to get control of his right arm.
Did there come a time when you took primary attempts at restraining him?
Yeah, I was trying to get his left arm free. He was trying to keep it under his body, so he wouldn't allow me access.
And when you say he was trying to keep it under his body, what specifically was he doing?
He was shoving it under his chest, trying to keep it so I couldn't grab his arm at all.
Were you giving any verbal commands at this time?
Yes, I told him all.
Go ahead, sorry, what were those?
No, I told him multiple times to stop resisting and give me his arm.
And did he do that in response to your commands?
No,
If you recall, sir, how many times do you think you attempted to take control of his arm?
I attempted at least 3 times to try to gain control of his arm before I was able to.
And what you've described as his pulling it away and shoving it under his chest, was that a consistent move at each time?
Yes,
Did there come a time when you did gain control of his arm?
yes.
And what happened next?
As I placed the handcuffs on his left arm, he grabbed the handcuffs and tried to pull them out of my hand.
Did you give any verbal statements at that time?
Yes, as I let go of the handcuffs.
And did he comply?
No, we had to pry his fingers off the handcuffs.
Did there come a time, sir, when he was taken into custody?
Yes,
And was he taken into custody by you?
yes.
What did you do next?
I got both handcuffs on him, checked for tightness, double locked them, sat him up, got him in my patrol vehicle and searched him.
Did you proceed, was he placed under arrest?
Yes,
For what?
assault and resisting and obstructing.
And did you proceed to the Lansing Detention Center?
Yes,
Was there a time that he left the Lansing Detention Center and went to Sparrow Hospital?
yes.
Why is that?
He was determined to be too intoxicated to be at the jail, need to be medically cleared.
And who makes that determination?
The jail detention staff.
Is that done by some type of breath test?
Yes,
Do you know the results of that?
he was actually unable to do it, but he was so inebriated he couldn't speak his own name too well, so they decided from there.
And did you take him to the hospital?
Yes,
What did you do with him at the hospital?
I brought him to the hospital. I got him checked in. I advised him that I'd be releasing him from custody at this time, but a report would still be taken. But I had a detainer placed on him.
Thank you. I have nothing further at this time for this witness, Your Honor.
All right, thank you. Mr. Austin, cross-examination.
Yes, Your Honor, thank you. Morning, officer.
Morning, sir.
So you arrived at the CATA station, whatever was occurring between Mr. Gary and the security there was already in progress, is that correct?
Yes,
And whatever precipitated that, you did not witness, is that correct?
correct.
And you were talking about trying to secure Mr. Gary, and he was pulling away and so forth. You recall that?
Yes, sir.
And where was the security guard when that was occurring?
He was on the right side of him. I was on the left side of him while he was on his stomach, while Gary was on his stomach on the ground.
And so the security guard was on top of him in some way?
He wasn't on top of him. He was on the ground next to him, trying to get control of his right arm.
And what span of time are we talking about from the time that you said you were trying to get Mr. Gary into compliance and he was pulling away and you were eventually able to do that? What span of time are we talking about here? Seconds, minutes?
I'd say a minute.
And were you by yourself or did you have a partner from the police department assisting?
I was by myself.
And what time of the day or night are we talking about here?
That was at 21, 23 hours.
And did you have your body worn camera at the time?
I did.
And do you know if it fully captured the interaction you
It
would
did
have
not.
with Mr. Gary?
It did not.
Why is that?
It fell off, and at the beginning of the initial struggle, fell off and then went under him. And then during the struggle, must have turned off.
Do you know at what time with your interaction with Mr. Gary that occurred? Was it right away or?
The camera fell off right away. I don't know. I can't remember exactly what time in the interaction it turned off.
And you're saying that the audio was disengaged as well?
Yes.
Whatever bit what was your body camera on before it got dislodged?
Yeah.
And whatever would have been captured before that happened, is that still available to the best of your knowledge?
Yes.
And at any time, did you speak with anyone from CATA to see if they had any footage that may have shown what transpired between Mr. Gary and the security guard before your arrival?
No, another officer did that follow-up.
Who was that officer, if you know?
Moshi, I believe.
And when you were interacting with Mr. Gary, did you believe him to be intoxicated or under the influence when you were dealing with him?
Yes.
And you talked about taking Mr. Gary to the hospital, is that correct?
Yes.
That was Sparrow.
Yes.
And you said you told him at that point he was released from custody, but there was a detainer?
Yes.
What does that mean?
So a detainer is placed on somebody when we can no longer sit on them at the hospital, which means security will contact us when they're ready to be released from the hospital, and we can come and get them. But they are not in custody at that time. They just let us know when they're ready to be released. We can come get them.
And so in other words, if Mr. Gary had said at some point, you know, I'm choosing to leave the hospital now, could he have done that without the police arriving and taking him into custody?
Once the detainer is placed, they will let us know. At that time, depending on the time, he could leave. Security can't force him to stay.
But if Mr. Gary was either being discharged or leaving, the police department would have been notified, in other words. Is that-
Yes.
And if that were to happen, what would happen when the police would arrive? Would he be taken into custody at that point?
Yes.
Thank you, Your Honor. I have no further questions.
Any redirect?
No, Your Honor, thank you.
May this witness be excused from the people,
Yes, Your Honor, thank you.
from the defense?
Yes, Your Honor.
All right, sir, you're excused. Thank you for your appearance today. Ms. Housefeld, you may call your next witness.
Thank you.
Yeah.
Thank you, Your Honor. The people would call to the stand Officer Joseph Traverso.
Officer Traverso, have you come up, stand right in front of me? Please state your name and spell both your first and last name for the record.
Joseph Traverso. It's gonna be JOSEPHTRA. As in Victor, ERS.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
I do, sir.
Okay, have a seat right here and please project for recording purposes.
Sir.
You may proceed, Ms. Housefeld, when you're ready.
Thank you, Your Honor. Sir, are you employed?
Yes, ma'am.
How are you employed?
I'm a police officer with the city of Lansing.
How long have you been with? In 23.
Yes, ma'am.
What shift do you work?
I work night shift.
And what are the hours of night shift?
It's 8:30 to 6:30 a.m.
So 8:30 p.m.
8:30 p.m. to 6:30 a.m.
So if you went into shift on March 3rd at 8:30 p.m., you would have been working into the 6:30 a.m. hours on March 4th, 2003. Is that correct?
Yes, ma'am.
Now, did there come a time on your shift that you were dispatched to Sparrow Hospital?
Yes, ma'am.
Do you recall the time that you were dispatched?
No.
Would it have been during that shift on either March 3rd, 2023 into March 4th, 2023?
Yes, ma'am.
And what was the purpose of your dispatch, sir?
We got sent to Sparrow Hospital, 1215 East Michigan, for an unwanted. It turned out to be Jerry Gary. Dispatch advised us that we had put a detainer on him earlier that day, so we were to transport him back to LPD lockup.
What is the detainer? What is the purpose of that, sir?
A detainer allows officers to leave someone at the hospital so they can carry about their business, while Sparrow Security advises us once they get released from the hospital.
And did you proceed to Sparrow Hospital?
Yes, ma'am.
And you understood it to be a pickup for Jerry Gary. Is that correct?
Yes, ma'am.
Okay. And did you locate a subject called Jerry Gary?
Yes, ma'am.
Did you have contact with him yourself?
Yes, ma'am.
And do you see him in the courtroom today?
Yes, ma'am.
Could you please indicate something that the subject you know to be Jerry Gary is wearing in court today?
He's wearing a blue jumpsuit.
Thank you, Your Honor. May the record reflect that the witness has identified the defendant.
Any objection to the witness identifying the defendant for prelim purposes?
Without objection.
Okay, without objection, the witness has identified the defendant.
Thank you. Now, sir, for purposes of a detainer, when you take a subject back, are they considered to be in custody at that time?
Yes, ma'am.
Okay. Are they placed in handcuffs like a subject would be in custody?
Yes, ma'am.
Typical routine of being placed in the vehicle, your patrol vehicle that is, and taken to the LPD detention center?
Yes.
And what is the address of the LPD detention center?
120 West Michigan Ave.
And that is in the city of Lansing,
Yes, ma'am.
County of Hingham?
Yes, ma'am.
When you took Mr. Gary back to the Lansing Police Department Detention Center, what happened next?
We take everyone to get booked in, so they go through our DO search process.
And what is a DO search process?
Detention officers search them.
Okay.
It's a more in-depth search than it would be done on the road going to lockup.
And what is the purpose of that?
To find any contraband, drugs, any other weapons that might be more hidden than could be found with roadside pat down, roadside search.
And are you present at the time that this occurs?
Yes, ma'am.
Were you present on this particular search of, I guess I should ask, was Mr. Gary searched in accordance with your DO search policies?
Yes, ma'am.
And were you present for that search?
Yes, ma'am.
And during that search, was contraband located?
Yes, ma'am.
Could you describe how that was found, please?
Detention officers had Mr. Gary in the cell and took off his sock. When they were taking off his sock, white, hard rock substance appearing to be crack fell out of his sock onto the floor. Officer Candell picked it up. We both observed it to be crack cocaine. We true narked the substance and it came back as cocaine base.
Okay, let's go through that a little bit. So you indicated that it fell from his sock. Was it loose, like a loose rock, or packaged?
A loose rock.
How many?
It was one large rock, big enough to actually pick up, and multiple little rocks that were scattered, hard to pick up.
Okay, and you indicated that Officer Candell picked it up, is that correct?
Yes, ma'am.
Okay, did he give it to you?
Yes, ma'am.
Okay, you said we true narked, but in fact,
I
did you
true
true narked? Okay, now, when you perform a true narc, are there steps that are taken to ensure the accuracy of that instrument?
Yes, ma'am.
And what are those, please?
There is a check that is performed before every true narc, and that check was conducted prior to true narking the actual substance.
Okay, and when you perform that check, what results do you get?
They passed.
And it says pass on the
Yes,
true narc?
yes.
Okay, so you receive a pass, you then scan the rock that was taken from his sock, is that correct?
Yes,
Okay, and you indicated that it did provide a positive result?
yes, ma'am. For
For-
cocaine base.
Okay, thank you. And then is there another test that is done after that test?
No.
Okay. Thank you. I have nothing further for this witness at this time.
Cross-examination, Mr. Austin.
Sure, thank you. Morning, officer.
Morning.
And you were talking about, you were the one that actually picked up Mr. Gare from the hospital, is that correct?
Yes, sir.
And the detainer search that you were speaking about, where precisely did that occur?
The detention officers searching him,
Yes.
that occurred in the jail, LPD lockup.
And, oh, I'm sorry, where you finished?
In the cell, sorry.
And is that something you personally witnessed?
Yes, sir.
And is that something that your body worn camera would have captured? You know,
I'm not sure if we have a lot of cameras in the jail, so usually we don't have our body worn cameras activated when we get up to the lockup.
there would have been actual cameras in the
Yes.
facility that would have been activated?
Yes.
You remember the name of the officers, the ones that were actually performing the search?
The detention officers? Yes, sir.
And the substance that you were talking about that was recovered, what happened with that after that was recovered? What were the follow-up steps on that?
It was tagged in as evidence once it was true narc, after being true narc.
That's something you did, or is that something somebody else did?
That's something I did.
And where's that substance at now, if you know?
I wouldn't be sure. To be fully honest with you.
And when you're tagging that into evidence, is that something you're doing wearing gloves?
Yes.
And that's to prevent contaminating that with your own fingers, correct?
More so to protect ourselves from the substance.
And is your understanding that Mr. Gary was originally in police custody and then taken to the hospital before you went to retrieve him?
Yes, sir.
Okay. And would he have been searched initially before going to the hospital? Is that part of the police policy, if you know?
I don't know what other officers did prior to me getting there, so I can't speak on that.
Is there a general policy regarding that?
If somebody's under arrest, they're supposed to be searched. I again, can't say whether or not.
Do you know how long Mr. Gary was at the hospital before you went to take him back into custody?
No, sir.
And you did not author your own separate report in this case, is that correct?
Yes, sir. I did not.
Thank you. That's all the questions I had.
Any redirect, Ms. Housefield?
No, Your Honor, thank you.
May this witness be excused from the people?
Yes, Your Honor, thank
From
you.
the defense?
Yes, Your Honor.
All right, witness, you're excused. Thank you for your appearance today.
Thank you.
Ms. Housefield, any further proofs?
No, no, Your Honor, thank you.
Okay. Any proofs from the defense today?
We'll rely on the evidence presented, Your Honor.
All right, motion for bind over?
Thank you, Your Honor. In this case, the people have filed a complaint alleging 2 counts. Count 1, controlled substance possession of cocaine less than 25 grams, and count 2, police officer assaulting, resisting, obstructing. I will state for the record that there is a 3rd count, which is a misdemeanor, that if one of the felonies is bound over will continue. But the court, of course, is only looking at probable cause standard at counts 1 and 2. The people indicated earlier, and I will renew those oral amendments, first to the middle name of the defendant being Jamar, Jimar. The people would move to amend at this time the date, based on the testimony today. I believe that it would be properly reflected to be March 3rd, 2023 through March 4th, 2023. And that count 1 occurred at the location of 120 West Michigan Avenue, Lansing, Ingham County, and that count 2, as indicated on the complaint, as 420 South Grand, City of Lansing, Ingham County. The people believe that the proofs today have met that probable cause standard. The taking sort of in reverse order of the testimony, but in order of the complaint, the officer just before the court testified that he picked up the defendant who he identified in court, took him to the Lansing Police Detention Center, which is in the City of Lansing, County of Ingham, and that during a search, which is part of the procedure for booking a person in, located in his sock a rock substance which was performed by TrueNarc to be positive for cocaine base. People believe it has met its probable cause burden there. With regard to count 2, Your Honor, you had the opportunity to hear from Officer McCrory. He indicated that on the date alleged and the location in the complaint, that he was in a fully marked uniform and a fully marked patrol vehicle, that he proceeded, or was dispatched rather, to the CATA bus station for an assault complaint. He proceeded there, that when he arrived, he found the CATA security detaining or attempting to detain the defendant, who he also provided an in-court identification for. That during the course of his contact with him, he made multiple verbal commands for him to stop resisting. The defendant refused to do so. He pulled his arm away on at least 3 occasions, placed it under his body. When he did finally get control of his arm and attempt to place handcuffs on him, the defendant pulled away and tried to grab the handcuffs. The officer stated that there was an additional verbal command at that time to let go of the handcuffs. This is an officer who was clearly had reason to be known to the defendant as an officer. He was performing a lawful discharge of his duties, which is responding to an assault complaint at a location for which venue is proper. And the defendant did, in the course of his actions, resist, oppose, assault, or hinder that lawful discharge of the officer's duty. People believe that it has met its burden with regard to count 2, and again would ask that count 3 proceed to circuit court.
Thank you. Response to the motion to bind over.
Thank you, Your Honor. The burden of proof, as the court is well aware, is probable cause at this stage, which is a relatively low burden. However, it is a burden that the people must meet. The court has heard the testimony. The court is the sole determiner of credibility at this stage. And I would just ask that the court weigh the testimony and evidence carefully, as I know the court will. And on behalf of Mr. Gary, I would close the bind over and ask that the matter be dismissed at this time.
Thank you, Mr. Austin. The court, so the location is let's start with the date. The date's amended to, was amended on the record by the people to March 3rd of 2023 to March 4th of 2023 on both counts 1 and 2. ID was made of the defendant by each witness. That's Officer McCrory and Officer Traverso. The venue is the city of Lansing, Ingham County. The location on count 1 is 120 West Michigan Avenue, and the location on count 2 is South Grand Avenue, 420 South Grand, city of Lansing, Ingham County. I find all of that has been met by a probable cause standard. Probable cause being the standard for preliminary examination. It's the second lowest standard in criminal law. It is the district court standard for preliminary examination. So we have the offense elements, and did in count 1, I find there's probable cause evidence to support the people's case for probable cause that the defendant knowingly or intentionally possessed less than 25 grams of mixture containing the controlled substance of cocaine, based on the Officer Traverso's testimony and the true narc test of that substance. I find there's probable cause to believe that the crime has been committed, and probable cause to believe the identity of the person who committed that crime as Jamar Gary. And then in count 2, I find from the officer, from the testimony of Officer McCrory, did resist, obstruct, or oppose or endanger Officer Maxwell McCrory, police officer of Lansing Police Department, and that the defendant knew was acting out in performance of his duties. Officer McCrory was in full uniform at the time, was attempting to subdue the defendant, as identified the defendant as the person who was making assaultive behavior, urinating in public at the CATA bus station. I find there's probable cause to believe that the crime has been committed and the defendant committed that crime. So I will bind over to circuit court on counts 1 and 2 as indicated per date and per different location that's been amended on the record. So I'm binding the cases over on counts 1 and 2. Count 3 will follow counts 1 and 2 to circuit court. Your time in district court on this file is over. This is bound over to circuit court, where the case will continue. So please keep in contact with your attorney, Mr. Austin, who will indicate what date you're set for arraignment in circuit court. Ms. Housefield, anything else for the record in docket 23-00712?
No, Your Honor, thank you.
Anything else for the record, Mr. Austin?
Briefly, Your Honor, given the earlier comment of Mr. Gary, if the court could confirm the status of Mr. Gary's bond on this case and what it is.
Yeah, we were working on that paperwork.
He did post bond with Lena's. They did surrender him due to, they just chose not to continue on the bond, so they surrendered him back to county, so that bond is void.
So he had no bond.
He has no bond. He's back. He has no bond posted.
Okay, so there's no bond posted, so I'll continue bond at 10,000.
Thank you, Judge.
So I've actually given a bond in the case as opposed to no bond given in the case. Anything else on the record, docket 23-00712, Mr. Austin?
Oh, Your Honor, thank you.
Okay, we're all set. Your next date will be for Mr. Austin in circuit court, sir.
Mr. Austin, did you need the transcript?
Yes, please.
Yeah. Did you get his, a copy of his order?
Yeah,
Mr.
Nathaniel
Fox?
had.
Okay,
Oh, I think so.
okay.
Yeah.
We'll see, Mr. Austin.
Have a good day, Josh.
You too. Ms. Hospital, did you want to go on Boulton or
Your Honor, I
you let
believe,
me know?
I believe that there may be a timeline waiver, and if all the parties are present, you could accomplish that.
Sure, you let me know.
So I think he was checking into. Oh.
Yeah.
Is that Mervine? Mervin? I think she's in,
She should be on Poly.
she should be on Poly.
Or no, she's downstairs. She's downstairs, sorry.
So, Mr. Silverthorne, that's your client?
That's correct, Your Honor.
And I think we're getting her.
Okay. Then I'll go get my witness lined up for the
All
next one,
right.
Judge.
And then, Mr. Abbott, you have Miss O'Reilly here?
Yes, Your Honor.
All right. Let's wait to see which assistant. Mr. Brodowitz, are you ready on Miss O'Reilly?
I believe so.
We can go ahead and put that one.
It's just. It's just completely. This.
In one of the files I asked, she left this. She's not looking at the job services that she got. She's the one that, who to love her, to like see such a community mental. Truly herself esteem reach here.
Right, I got it.
But we just wanted to make sure that we didn't.
All right, so we're on the record in docket 22-02303 and 22-03192. That's People of the State of Michigan versus Courtney O'Reilly. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Courtney O'Reilly. She is president standing to my right.
Ma'am, you are Courtney O'Reilly? All right. This is the time set for, this was a review date and a contempt of hearing date concerning this matter. Mr. Brodowitz, how are we proceeding today?
I believe this morning, Your Honor, that the defendant is going to plead to the contempt charges. So being as that is my understanding, I will defer to the defense.
Mr. Abbott, we have an outstanding order in this case. Go ahead and make a record, so.
Thank you. I'm here on both, Your Honor. I have not yet received a copy of the petition and order regarding the show cause, but I've discussed the situation with Courtney O'Reilly and she says she has relapsed. So I'm guessing that that's the basis of the problem.
That is the basis of the problem.
Okay, so she will admit, Your Honor, that she did test dirty in the first week of March. And she relapsed with methamphetamine. Otherwise, Your Honor, once that's entered, I'll.
So we'll talk about what options we have from today. All right. All right. You understand, Miss O'Reilly, that the allegation is that as a condition of bond that you not possess or ingest any THC or drug or controlled substances. You understand that, ma'am?
I understand.
All right. And that's the allegation's been made from pretrial services that you tested positive. It's my understanding you wish to waive your rights to a hearing in this matter. We could bring witnesses and have them testify of the allegations. It's my understanding you wish to waive your rights to the matter and you wish to admit responsibility to the violation of the pretrial services order. Is that correct, ma'am? All right. So I'm gonna raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury? The allegation is that you tested positive for THC on February 10th, 2023. Do you contest that allegation in any way? That's true. There's another allegation that you tested positive for THC and methamphetamines on March 2nd of 2023. Do you contest that allegation in any way?
That's true.
Okay. I find that the testimony to be knowing, voluntary, and accurately made in regards to the contempt violations. Now I'll ask from both parties. We've been waiting for a review of my understanding is the defendant was found incompetent.
Correct, Your Honor.
And then we're waiting for review for competency or a re-review for competency based on the person getting ready, getting reevaluated. Is that correct for competency purposes?
Yes, although the reevaluation has not occurred yet, Your Honor.
Right.
I have received a letter, which I think was addressed to you.
Right.
February 8th regarding current availability of placement and the options to treat. It's an outpatient. And she has been pursuing that program, Your Honor. She initially had a little trouble getting a place that would take her insurance. She started with Lifestance Psychiatric and they wouldn't take her insurance. She's now working with Mid-Michigan Recovery Service, and she met with them last week. She intends to meet with them again tomorrow. She's also met with CMH, and they've assigned her a therapist, Judy Hunt, at Waverly Wellness. She met with her last week and yesterday.
All right.
So she's meeting with them on a weekly basis. In addition, it's my understanding that Ms. Hunt has referred her to a psychiatrist, which, although she doesn't know her name, she thinks she has an email or a message, a voicemail indicating a meeting with a psychiatrist is in the works. So she is moving in the right direction, Your Honor. She's taking advantage of the services that are available outside. And although she did drop dirty, then she's going to be dropping again today. She tells me she expects to drop clean today.
All right. We've set this for review on April 6th. Is that right? Just to see, I have it scheduled for review on April 6th.
Yes.
In order. Miss O'Reilly, I'm running out of options on some level. Okay. You do the actions of your actions here of awaiting for you're waiting to be reevaluated for competency purposes. But in the meantime, there are pretrial orders that indicate that you can't be on THC and you can't have methamphetamines. And I know that's a slippery slope on some level. However, you've come in, you've owned up to your responsibilities, and your counsel's indicated that you have a plan right now. The plan is with CMH and with what was the second recovery services?
Mid-Michigan Recovery?
Yeah, Mid-Michigan Recovery.
Waverly Wellness.
Okay. And you've also, I know insurance is a mess concerning some of this, but you've able to work out, be able to work out at least in regards to one of the treatments there in centers that the insurance will cover. Is that my understanding?
Yes, my drug counseling is covered by my insurance.
Okay. So this, if anything, is just a wake-up call for you, okay? If this continues, if you drop dirty today and then you drop, I'm gonna run out of options and I'm not gonna know where to put you. And the one place I don't want to put you is back in jail, right? Because that's not gonna help you and it doesn't help me and it doesn't help everybody else.
Yes, sir.
You know, there are things that you've got to take care of. You know that and I know that, all right? So let's work from that, okay? Let's work from that. You've got a plan. Let's stick to the plan. But you can't drop dirty under pretrial services. You'll just end up in front of me again, and then we'll go through the cycle again. And we kind of want to stop that, right? That April 6th date is we'll reevaluate where we're going with this. My understanding is that's a date set. We don't have a reevaluation date for competency purposes yet from from the forensic center. Is that my understanding, Mr. Abbott?
I have not received one.
Yeah, I don't have one either. I am gonna have, we're gonna have CMH in here. I think we have another hearing. We held them in contempt.
It was dismissed because they got the other.
Okay. We initially held them in contempt, and then they've retained them Nichols Law Firm in regards to. So we're pushing these cases so that we have an answer, and so that you have an answer, because it's important for you to have an answer. I'm not afraid to do that again, but let's see what April 6th brings. Okay.
Okay.
So Ms. O'Reilly, just keep on the plan, all right? And I'll tell you, if we get more tested positive, we just end up in the same place. And you've got to have better things to do with your time, right? Okay, all right. So bond is continued. We're still awaiting. We'll have the April 6th date, and then just we'll look at this as kind of a wake-up call, all right? All right. Anything else for the record in docket 22-03-192 or 22-02-303? Mr. Brodowitz.
Nothing from the people. Your Honor.
Mr. Abbott.
Nothing from the defense. Thank you.
All right, Ms. O'Reilly, we'll see you on April 6th. Take care, okay?
Thank you.
All right. I guess I should write in the file.
Yes.
I know.
That's people of the state of Michigan versus Douglas Boulton. Will the parties please introduce themselves for the record?
Thank you. Good morning, Your Honor. Erin Housefield on behalf of the people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Bolton, who is seated to my right.
Sir, you are Douglas Bolton?
Yes, I am.
All right. This is the time set for preliminary examination today. Mrs. Housefield, how we proceed?
Thank you, Your Honor. It's my understanding that defendant wishes to run the preliminary examination. The people do have the appropriate witness and are ready to proceed.
All right. Is there anything to come to the court's attention before we start the preliminary examination? I just sounded like oh, who knows? Mr. Goodrich, anything come to the court's attention?
No.
Okay, I don't see any witnesses or suspicion. All right. All right.
Nothing for the people, Your Honor.
All right, thank you. Ms. Housefield, you may call your first witness.
Thank you, Your Honor. The people would call to the stand Trooper Razy Jupin.
All right, Trooper Jupin, I'm gonna have you come up here.
Yes, sir.
Please face me and state your full name and spell both names for the record.
Trooper Racy Jupin, first name Racy, R-A-S-E-Y, last name Jupin, J-U-P-I-N.
Please raise your right hand, which you are. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, please have a seat and please project for recording purposes. And Ms. Housefield, when you're ready.
Thank you. Good morning, sir.
Good morning.
Are you employed?
I am
How are you employed?
with the Michigan State Police.
And are you on a special assignment?
I am.
And what is that?
I work SCP, which is Secured City Partnership, in conjunction with Lansing's Violent Crime Initiative team.
And what is the purpose of that assignment?
Our purpose is to mitigate violent, violent acts.
And do you have a specific focus within your assignment?
Yeah, anything that would be deemed violent as far as firearms, which also go hand in hand with narcotics.
How long have you been on that assignment, sir?
Just under 3 years.
Sir, were you on duty on October 27th, 2022?
It was.
And did you have a specific assignment within your role with VCI Secured Cities Partnership on that night?
Yes, we were conducting compliant checks with parole.
And what do you mean compliance checks?
Somebody that is on probation or parole, they sign an agreement and they are open to compliance checks at their residence through probation and parole at any given time.
And on this occasion, did you have a specific probationer that you were seeking a compliance check on?
Was
And who was that person?
Mr. Douglas Bolton.
And did you have a specific residence?
Yes,
And what was that residence?
it was on Norman Street. I believe the numbers were 311.
Are you, and I'm sorry, what city is that in?
Lansing,
Ingham County?
correct.
And did you on that date proceed to that location?
Yes.
Okay. And when you do this, who are you with?
For this specific time, we were with probation and one of the probation agents through Ingham County.
And did you make contact at the residence?
We did.
Did you make contact with any person?
Yes, Mr. Bolton,
You say Mr. Bolton. Do you see Mr. Bolton here today?
I do.
And could you please indicate for the court what the person you know as Mr. Bolton is wearing today?
Yes, a blue Michigan polo.
Your Honor, I would ask that the record reflect that the witness has identified the defendant.
Any objections from defense?
No objection, Your Honor.
The witness is let the record reflect the witness has identified the defendant.
Thank you. Now, when you make contact with a subject, sir, for a compliance check, do you advise the person that that's why you're there?
Yes, mostly it's the probation agent that speaks to them, or parole agent, depending what it is, speaks to them, let them know why we're there.
Okay, were you present for that?
I was.
Okay, and so once you determine with the subject that that is the purpose of being there, what's the next step?
The next step is just making sure that they are in compliance with their guidelines through probation and checking to make sure that they're following whatever their guidelines are.
So in this particular instance, would the compliance check have covered the entire residence?
I don't know if it would have been the entire residence, but it is living areas and then common areas like bathrooms, living rooms, and then specific bedrooms.
Okay. And so in this case, did you determine the defendant's specific bedroom?
Yes,
How did you determine that?
I asked Mr. Bolton specifically which bedroom was his.
And did he give you an answer?
He stated it was the first bedroom on the left up the stairs.
And did you proceed to that bedroom?
Correct,
Did you search that bedroom?
I did.
And what, if anything, did you find and seize?
Located several different narcotics, scales, baggies, even located his identification within the bedroom.
Now, when you say within the bedroom, let's go through specifically with regard to the narcotics. You indicated several different narcotics, is that correct?
Yes,
And were these narcotics found together or in various places?
together.
And where were they found together?
It was in a like a blue zip baggie between the bed and the nightstand.
And you said several different narcotics, is that correct?
Yes,
Based on your time with BCI and Secured Cities Partnership, you indicated that the purpose of that is the reduction of violent crime and typically focusing on firearms and narcotics. Is that correct?
correct.
So your time on the street, has that allowed you to have contact with a variety of controlled substances?
Yes,
And based on your experience, are you able to identify at least suspected narcotics based on their appearance?
correct.
So in this case, what did you believe the narcotics were?
At the time, I believed that there was black tar heroin, methamphetamine, crack cocaine, and then there was a mixture I was unsure of at the time.
Now, you indicated, sir, that you found, was it one or more scales?
Multiple scales
Okay, and where were those located?
on or near the nightstand that was next to the bed.
And you indicated you found baggies, is that correct?
Yes,
Were those baggies with or without narcotics?
some had narcotics in it, some did not.
Now, are you familiar, sir, with the way that narcotics are packaged for trafficking?
I am vaguely familiar.
Based on your experience,
based on
as you've described?
experience. Yes.
And typically, what is it, or how is it that narcotics are packaged for trafficking?
For packaging purposes, there's more quantity within a single packaging. For use, less amount within a single packaging.
Is there a particular package that's utilized by traffickers?
Yeah, usually it's a plastic, like sandwich baggie that doesn't have the Ziploc on it, without the Ziploc, so they can tie off whatever they are packaging into the corner of it.
And are those the types of baggies that you located?
Yes,
And in fact, were those the types of baggies that contained the narcotics that you did find?
don't recall all of them. I know some of them were.
Now, you've indicated a variety of drugs, and I would like to take them separately. You said you believe that you found black tar heroin, is that correct?
Yes,
And you believed it to be that based on its appearance?
correct.
And did you seize that item?
I did.
And what did you do with it?
I completed a true narc at the Lansing Post.
And did you receive a positive result for controlled substance?
I did.
And what was that result?
Fentanyl.
Was that item sent for any further testing?
No,
Do you recall the weight on that, sir?
I don't.
Would it be in your report?
It would be.
Would it help to refresh your recollection?
It would be.
Is this your report here?
It is.
Your Honor, may I approach the witness?
You may.
And Your Honor, I will state for the record that the witness is reviewing Michigan State Police Incident Number 11-4080-22.
Record may so reflect.
Thank you, sir. Once you've had an opportunity to review that, if you'll just look up. Did reviewing your report help to refresh your recollection?
Did,
And do you recall or did you note the weight of the, what tested as fentanyl?
I did.
And what was that weight, sir?
16? Was it 18? Sorry.
Do you need to look in your report again,
Yeah,
sir?
I'm sorry.
Please do.
All right. It was 18
And would that be, what was the unit of measurement, sir?
grams.
Thank you. Now, you indicated, sir, that you also believed that you found suspected methamphetamine. Is that correct?
Yes,
And did you believe it to be methamphetamine based on its appearance?
correct.
And did you do any testing on that?
I did. True narc.
Now, did you find more than one baggie of suspected methamphetamine?
Found multiple.
And did you log into evidence one baggie that was 44 grams and one baggie that weighed at 1 gram?
Correct.
And did you do a test on both of those?
Yes.
Okay, and what test did you do?
The true narc.
And let's take them separately. The baggie that is logged in as 44 grams weight, what was the, did you receive a result on that?
Yes, positive for methamphetamine.
And with regard to the baggie that has been logged in as 1 gram, did you receive a result on that?
Yes, positive for methamphetamine.
You indicated you also believed that you found what you knew to be crack cocaine, is that correct?
Correct.
And was that based on the appearance of the substance?
Correct.
And did you perform any test on that?
I used true narc.
And did you receive a positive result?
Yes, for cocaine-based substance.
And then you indicated that you took what was a mixture, I believe you identified it as a blue mixture in color, is that correct?
Blue homogeneous mixture.
Okay, and what did you do with that?
I true narked it initially and then had it sent to the lab.
And do you know if the lab has returned results on that?
They did.
Now, sir, in your time with VCI Secured Cities partnership in the narcotics and firearms offenses, have you had occasion to come into contact with people who are using narcotics?
Yes.
And when you do that, and do these people have narcotics on their person?
On or about their person, yes.
And typically, and I understand that things vary, but generally speaking, is there a weight for a drug, and we can take the drug separately, that a user would have that would be different than somebody who is trafficking?
Absolutely.
So taking the drugs, let's start with fentanyl. Generally speaking, what is a user amount for fentanyl?
Usually, in my experience, fentanyl is mixed with something, so it's very rare unless you're dealing it for it to be by itself.
Okay. Methamphetamine, is there a typical user amount for methamphetamine?
In my experience, it's been usually half a gram to a gram that a user will possess.
And what about crack cocaine?
Around the same, about a half to 1 gram.
And in your experience, sir, how is it that scales factor into drug trafficking?
A lot of times for trafficking drugs, they'll have weights to make sure the scales are accurate and then use the scales to portion their narcotics within whatever the user is buying or purchasing at the time.
Now, did you do an interview with the defendant?
I did.
And did you talk to him about the narcotics?
I did.
And did he make a statement to you regarding the narcotics?
Yes, he stated that he uses.
And did you have a follow-up conversation after he made that statement?
I had advised him because of the amount of narcotics, the bags, and the scales, that it is very uncommon for somebody to only be a user with what was located.
Did he say anything after that?
I don't recall.
Thank you. I have nothing further of this witness at this time, Your Honor.
Cross-examination?
Your Honor. Sir, did you, so you said you found 18 grams of fentanyl, or I was confused.
18 grams of fentanyl within what I thought was the heroin.
Okay. But then there was also this blue mixture.
Correct.
And that's was that located in plastic baggies?
Yes.
Now, when you weigh drugs like that, do you generally take them, kind of dump it out of the bags and put it on the scale, or do you keep it in the bags to weigh?
Stays within the bag.
Okay. And how many of these baggies did we have?
I don't know a total.
If the lab report showed that they received 6 bags, would you dispute that amount?
Usually we don't, the lab only will take, like, if it's the same substance, they won't take 6 baggies of the same substance. So you send them one of what it is and then they test it. If that makes sense.
Well, okay, so if they test it to determine the substance, correct?
Yes,
Do they ever weigh the substance?
they weigh it.
Okay. When you've talked about how often narcotics are sold by a half gram or a gram's not a lot of weight, is it?
No.
In fact, some baggies themselves might weigh a gram, a single gram or close to a gram, correct?
I guess depending on how big the bag is.
Okay. And if you had several bags that you were weighing, that might account for a couple grams, correct?
Depending on the type of bag.
Okay. And specifically with these bags that had fentanyl, if you had 6 of those bags, is it certainly possible that you had 2 or more grams worth of baggie, and the rest of it would be the fentanyl mix?
Yes, it depends on what the bag was. I don't recall exactly. If it was one of the corner tie-off bags, then it would not be up 2 grams worth of bags.
Okay, so not even when you have several bags.
Depending on how many bags you have. But the corner, like the sandwich bags that I talked about earlier, they're not up to a half a gram or a gram a piece.
Okay, but if we had, what I'm saying is, if we sent 6 of them to the lab, is it your testimony that the 6 of them combined could not weigh 2 grams?
I have no idea.
Okay, so you're unclear. When you spoke with my client, you previously testified that it was his statement that he had been using drugs but not selling, correct?
Yes.
And you never heard anything different?
Nope.
How were there other people in this house when you arrived?
There were.
Was there more than one other person?
If I recall correctly, I think there was 2 additional to Mr. Bolton.
Okay, well,
but I don't recall.
Okay, so when you
more than one.
But you went to this house. What time of day do you think it was?
It was later in the evening.
And Mr. Bolton did answer the door for you?
Somebody else answered the door and then got Mr. Bolton, who ended up coming to the door.
Okay, so then you go into like the common area of the house?
Yes.
And that's where these other people were seated?
Correct.
And Mr. Bolton was downstairs at that time that you came into the house?
Correct.
Did Mr. Bolton resist you searching his house in any way?
No.
Did he direct you where to look in where his room was?
He told me where his room was, yes.
Did he resist being handcuffed or arrested in any form or fashion?
I was upstairs when he was handcuffs, but I did not hear anything outside of that, so I don't know if he resisted or not during that.
Okay, but you spoke with him at some point while he was handcuffed?
Yeah.
And you in fact took the handcuffs off of him and basically told him to have a good night after that, something along those lines?
Yes.
Okay, and all right. Now, you stated that what part of this initiative was searching for guns, correct?
Well, that's what we do on the team, not for this specific incident.
Well, he would, I don't know, if were you aware that he was on probation for some type of a gun offense? Is that why you were there?
I know that he was on probation. I didn't know the specifics as far as what he was on probation for. But because of the probation agent, they have all that documentation. And then we follow suit with that agent as far as completing the compliance check.
And you stated previously that guns and selling drugs kind of go hand in hand. Is that fair from your experience?
It is.
Did you find any firearms in Mr. Bolton's residence?
I did not.
No further questions, Your Honor.
Redirect.
Just one, because I don't know if it was made clear in the initial testimony. Sir, you indicated the crack cocaine was seized, is that correct?
Yes,
Do you recall the weight on that?
I want to say it was a gram. Don't know specifically.
Is your recollection that it was a low amount?
Yes.
Thank you. I have nothing further for this witness at this time, Your Honor.
All right. May this, any objection to this witness being excused from the people?
No, Your Honor, thank you.
From the fence? Witness, you're excused. Thank you for your appearance today.
Thank you.
Ms. Housefield, any further proofs?
Yes, Your Honor, thank you. At this time, people move for admission of people's proposed exhibit number 1. It is an MSP laboratory report. People move for that pursuant to MCL 766.11B.
Any objection?
No, Your Honor.
Okay. Without objection, People's Exhibit 1 is admitted into evidence.
Thank you.
Any further proofs, Ms. Housefield?
Nothing for the people, Your Honor, thank you.
Any proofs today, Mr. Goodrich?
No, Your Honor.
Motion for bind over.
Thank you, Your Honor. The people have filed a complaint in this matter alleging 3 felonies with a habitual offender 4th offense notice. It is alleged that these crimes occurred on or about October 27th, 2022 at 311 Norman Street, City of Lansing, Ingham County, making venue appropriate in this court. The officer testified, or the trooper rather, testified today that he proceeded to this location. It is the residence of defendant. He identified defendant in court for the purpose of a compliance check. He located a variety of items in the bedroom that was identified by the defendant as being his. Those items included multiple narcotics, multiple scales, and baggies that, according to this trooper's training and experience, are associated with drug trafficking. They're plastic baggies, which he called a tie-off baggie. The total on these items, Your Honor, that was seized, there was 18 grams of fentanyl, which TrueNarc positive. There was 62 grams of suspected fentanyl, which was later sent to the lab. That is the people's proposed exhibit number 1. That is 51.80 grams of fentanyl. Additionally, there were 2 baggies of meth, one that totaled 44 grams and one that totaled 1 gram, both of which TrueNarc positive for methamphetamine, and that there was approximately, in the officer's recollection, 1 gram or at least a low amount of crack cocaine that was located and TrueNarc positive for cocaine base. In this case, Your Honor, the people have charged with regard to the fentanyl and the meth that the defendant did possess with intent to deliver, and with regard to the cocaine, just simply possessed it. People believe that they have satisfied by a probable cause standard based on a variety of things, including the weight, the other paraphernalia, the baggies, the scales, and the just location and combination of multiple narcotics being held by the defendant to support the possession with intent to deliver as to counts 1 and 2, and certainly that the defendant possessed the cocaine less than 25 grams with regard to count 3. So people would ask for bind over on all 3 counts.
Thank you. A response to motion for bind over.
Your Honor, at this point, we would just ask the court to consider all the evidence that's been presented and make a decision based on the evidence in this matter, Your Honor.
Thank you. So the court finds, the court has a standard of probable cause, that being the second lowest standard, reasonable suspicion being the lower standard in criminal law. And the court finds by probable cause evidence that the location is correct here of 311 North Norman Street, the date of October 27, 2022, venue City of Lansing, Ingham County. Identification was made by the single witness, Officer Jupin, indicated that during a probation really compliance check, that the substance was found in the sleeping area of the defendant, which the defendant indicated was the sleeping area of a methamphetamine with scales and bags, and the methamphetamine was in the amount of 51 grams. Which is a substantial amount of methamphetamine. So I find by count 1, by probable cause evidence and bind over on count 1, that the defendant did possess with intent to deliver the controlled substance of methamphetamine. In count 2, I find by probable cause evidence, similarly, that the defendant did possess with intent to deliver 50 grams or more, but less than 450 grams containing controlled substances of fentanyl, which is a cutting agent generally. And then that was found in, I think, the fentanyl, if I have it written down correctly. The fentanyl was found in 54 grams. Is that correct?
So Your Honor, the people's proposed exhibit.
18 grams.
18, and then there was an additional baggie of 62, which was sent to the lab,
Right.
which we now know the weight to
Right.
be 51.80.
So I find by probable cause evidence that is a substantial amount of fentanyl. So did possess with intent to deliver 50 grams or more, but less than 450 grams in count 2. And in count 3, there was a 1 gram possession of cocaine that was found with the other controlled substance. I find in count 3 that the defendant is knowingly or intentionally possesses less than 25 grams of a controlled substance of cocaine. That's a possession charge. So I'll bind over on all 3 counts. In the interim, I see bond is $30,000, 10%. It's my recollection here that this is habitualized to life, if I see the notice correctly.
That is correct, Your Honor.
I also would note for the record that the defendant has not been able to keep his eyes open through the majority of this preliminary examination. I mean, he is truly struggling to keep his eyes open during this process. So before I bind over, I'm remanding the defendant to the Ingham County Jail without bond. Bond can be revisited in a circuit court. So I'm basing that based on the nature of the offense, the nature of the habitual, and then the defendant's own conduct here in court today. So with that understanding, any bond can be revisited in circuit court, which will be the next available date. I'm binding the case over as charged. Any questions concerning this file, Ms. Robinson?
Ms. Housfield, no, thank you.
Ms. Housfield, did I just call you Ms. Robinson? Mr.
Throwback.
Goodrich, I'm
Throwback,
so sorry. Mr. Goodrich, any questions concerning the bind over at this time?
No, Your Honor.
Thank you. All right, your next date will be from Mr. Goodrich, who's your lawyer. Please keep in contact with him. Your next date will be in circuit court.
Mr. Goodrich, did you want the transcript?
Yes.
I called you Mrs. Robinson. That's a cheap shot, isn't it?